Every generation faces a moment where the Supreme Court must choose whether it will defend the Constitution or let political pressure rewrite it. For millions of Americans, Duncan v. Bonta is that moment. And when the court suddenly schedules a case that could define the future of the Second Amendment, you can bet the stakes are far higher than they're willing to admit publicly. This case is no mere legal battle. It's a decision that could shape the future of our fundamental rights. California's aggressive ban on magazines over 10 rounds isn't just a state issue. It's a challenge to the very principles on which this country was built. The Supreme Court now has the chance to make history. Will they stand firm for the Constitution or let a single state's laws set the precedent for the entire nation? Let's start with the basics. California passed a law targeting what it calls large-capacity magazines, any detachable magazine that can hold more than 10 rounds of ammunition. The state doesn't just regulate the sale or import of those magazines. It makes it a crime to manufacture, import, buy, sell, lend, give away, or simply possess them, with only narrow exceptions. The law also tells people who have already owned those magazines that they have 3 options: remove them from the state, sell them to a licensed dealer, or surrender them to law enforcement for destruction. That is forced dispossession, plain and simple. The plaintiffs in Duncan v. Bonta argue that these magazines are part of the arms protected by the Second Amendment. They are standard equipment for many modern handguns and rifles, and they are owned by millions of Americans for lawful purposes. California, in contrast, tries to rebrand them as mere accessories that the state can ban whenever it wants. So the core question is, this are commonly owned magazines over 10 rounds protected arms, or just politically disfavored hardware that can be wiped out whenever a legislature feels like it? This fight started in Sacramento and at the ballot box, not in Washington. In 2016, California lawmakers pushed through a package of gun control measures, and voters piled on with a ballot initiative. Together, they moved the state from limiting sales to banning possession of magazines that hold more than 10 rounds, with the new rules kicking in around July 1, 2017. Before that deadline, gun owners went to court. Virginia Duncan and several other plaintiffs, backed by the California Rifle and Pistol Association, filed suit in federal court. They argued that California's magazine ban violated the Second Amendment and also amounted to an unconstitutional taking of private property without just compensation. The case landed before Judge Roger Benitez in the Southern District of California. In 2017, he issued a preliminary injunction blocking the state from enforcing the possession ban. In 2019, he went further, granting summary judgment for the plaintiffs and striking down the law as unconstitutional. He emphasized that magazines with over 10 rounds are not unusual. They are standard for many of the most popular firearms in America. The state appealed. A 3-judge panel of the Ninth Circuit initially affirmed Judge Benitez, agreeing that the law violated the Second Amendment. But then the Ninth Circuit took the case en banc. A larger group of judges reheard it, and in 2021, that en banc panel reversed course and upheld the ban under the old 2-step interest balancing framework. In 2022, the Supreme Court handed down the Bruen decision, throwing out that 2-step test and replacing it with a pure text and history standard. If the Second Amendment's text covers the conduct, the state must justify its restriction by pointing to a historical tradition of similar regulations. In light of Bruen, the Supreme Court sent Duncan back to the Ninth Circuit, and the Ninth Circuit sent it back to Judge Benitez. In September 2023, Benitez again struck down California's magazine ban, this time explicitly using Bruen's framework. The state appealed again, and the Ninth Circuit pulled the case en banc again, setting the stage for its 2025 decision. On March 20, 2025, a deeply divided en banc Ninth Circuit issued a new opinion in Duncan v. Bonta, holding that California's large-capacity magazine ban does not violate the Second Amendment. The majority did something critical right up front. They said that magazines over 10 rounds are not arms within the meaning of the Second Amendment. Instead, they labeled them accessories or accoutrements. In other words, parts that are related to arms, but not arms themselves. That move matters. Under Bruen, if the conduct is not covered by the plain text of the Second Amendment, the state doesn't have to carry the heavy burden of proving a historical tradition of similar regulations. By saying magazines aren't arms, the Ninth Circuit tried to avoid the most demanding part of Bruen altogether. The majority also argued that even if magazines are protected components, California's ban fits within a historical tradition of regulating especially dangerous weapons and restricting certain features thought to increase lethality. They pointed to a small set of historical laws and treated those as close enough analogs. Several judges dissented sharply. They argued that magazines are integral to the operation of modern firearms, that magazines over 10 rounds are plainly in common use nationwide, and that Bruin and Heller make clear that arms in common use for lawful purposes cannot simply be banned. From that perspective, the majority's approach looks like a way to sneak interest balancing back in through the side door. Politically, California's leadership celebrated the decision as proof that their ban is common sense and life-saving. For gun owners, the message from the majority was simpler. Your magazines are not really protected, and your right to keep effective tools for self-defense can be trimmed down whenever a court decides to call them accessories. After the Ninth Circuit's 2025 ruling, the plaintiffs took the final step available. They asked the U.S. Supreme Court to hear the case. They filed a petition for certiorari, asking the court to decide whether a state can ban magazines that are widely owned for lawful purposes, and whether forcing owners to give up or destroy those magazines is an unconstitutional taking. The case was docketed as Virginia Duncan et al. Versus Rob Bonta, Attorney General of California. For a brief moment, it looked like we were about to get an answer. The Supreme Court distributed the case for conference on November 21, 2025. That is the private meeting where the justices decide whether to grant review, deny the case, or hold it. Then, without fanfare, the docket changed. The November 21st conference disappeared, and a single word took its place. Rescheduled. No explanation. No new date. Rescheduled does not mean denied. It simply means the court moved the case to a different, undisclosed conference. That can happen for many reasons. A justice may want more time. Some justices may want to discuss Duncan alongside another magazine case, or internal votes may be shifting. But from the outside, the effect is the same. A case that could decide the fate of magazine bans nationwide was about to be discussed, and at the last minute, the court kicked it further down the road. While dockets are being updated in Washington, real people in California are left in limbo. On paper, California's magazine ban still demands that owners either remove, sell, or surrender their magazines over 10 rounds or risk criminal charges. Over the past several years, they have lived through a confusing mix of injunctions, stays, brief windows of legality, and new appellate decisions. That means ordinary gun owners have had to ask over and over again, is my property legal today? Will it be illegal next month? Am I supposed to destroy it? Or can I keep it? That is not how a fundamental constitutional right is supposed to operate. The Duncan petition points out that magazines over 10 rounds are standard equipment on many of the most popular firearms in the country, and that hundreds of millions of them are in circulation. When a state declares those magazines contraband, it is not targeting some niche accessory. It is attacking the way modern firearms are actually built and used. If courts are allowed to say that these magazines are not arms, and that banning them is just a reasonable safety regulation, then there is nothing that stops other states, or even Congress, from copying the same model. Duncan v. Bonta is part of a bigger national picture. Other jurisdictions have imposed similar magazine bans. Some federal courts have upheld them. In a few recent cases, the Supreme Court has declined to step in, leaving those bans in place for now, even while some justices have openly signaled that they are ready to enforce Bruin more rigorously. At the same time, some state courts have taken the same path as the Ninth Circuit, declaring that large-capacity magazines are not arms at all. That creates a growing conflict with decisions and scholarship that treat magazines as integral, protected components of modern firearms. Industry data show that magazines over 10 rounds make up a huge share of the magazines sold in the United States. In other words, they are plainly in common use. That fact sits at the core of the plaintiff's argument that Duncan is the right vehicle for the Supreme Court to finally say whether states can ban standard capacity magazines. If the court ultimately denies Duncan, hostile states will read that as a green light to keep or expand their bans. If the court grants the case and reverses the Ninth Circuit, Duncan could become the decision that knocks out similar magazine bans across the country. There is also a debate inside the Second Amendment community about timing and tactics. Some people argue that the Supreme Court should wait for a perfect hardware case about rifles or handguns and avoid magazine bans for now. They worry that emotions and politics around mag bans make them risky vehicles. That argument is easier to make if you live in a state that respects your rights, where owning a standard magazine doesn't put you at risk of prosecution. It sounds very different if you are in California, staring at a law that effectively says an 11th round in your magazine could make you a criminal. Suppose a strategy requires the court to ignore a case where millions of people can be turned into lawbreakers overnight for keeping something they lawfully bought. In that case, that is not a strategy grounded in principle. The Supreme Court has plenty of capacity to take both a hardware case and Duncan in the same term. Duncan is not a distraction. It is one of the main fronts in the current fight over the Second Amendment. So where does that leave us? Duncan v. Bonta is sitting on the Supreme Court's docket. The original conference date has vanished. One word, rescheduled, now sits between millions of gun owners and clear guidance on their rights. The Ninth Circuit says your magazines aren't arms. California says you should give them up or face prosecution. And for the moment, the highest court in the land is silent. I'll keep tracking every movement in this case and breaking it down for you. If you're serious about defending the Second Amendment, make sure you subscribe, share this video with a friend, and stay in the fight with me. Silence is exactly what the other side is counting on.